Hello and welcome to Verdictum. This is Krishna Rana and today I am going to explain to you a few interesting judgments of this week from the Supreme Court. Whether government servants are entitled to claim benefit of double overtime allowance at par with factory workers as per Chapter 4 of the Factories Act. In the case of Security Printing and Minting Corporation of India Limited and others versus Vijay D. Kasbe and others, the Supreme Court of India clarified that the persons holding civil post or in civil service of the state enjoy certain privileges and hence the government employees cannot claim overtime allowance as per the Factories Act if the service rules do not provide for it. Elaborating it, the bench of Justices V. Subramaniam and Pankaj Mittal said that persons who are not holders of civil post nor in the civil services of the state but who are governed only by the Factories Act may be made to work for 6 days in a week with certain limitation as to weekly hours under Section 51, weekly holidays under Section 52, daily hours under Section 54, etc. Workers covered by Factories Act do not enjoy the benefits of automatic wage revision through the periodic pay commission like those in government service. Overturning the judgment of Bombay High Court, the bench significantly noted that the claim of the employees were not based on any service rule but on Section 59(1) of the Factories Act. Since the governing service rules did not provide for any overtime allowance, their claim was held to be untenable. Mere unnatural death of wife in matrimonial home within 7 years cannot be a sole ground to convict husband for dowry death. In the case of Charan Singh versus the state of Uttarakhand, the bench comprising Justice Abhay S. Oka and Rajesh Bindal held mere death of the deceased being unnatural in the matrimonial home within 7 years of marriage will not be sufficient to convict the accused under Section 304B and 498A IPC. The Apex Court, while acquitting a husband who was convicted under Section 304B, 498A and 201 of the IPC for the death of his wife within 2 years of marriage, stated, to entail a person under the ambit of dowry death case, the prerequisites to raise presumption under Section 304B IPC and Section 113B of the Indian Evidence Act has to be crucially fulfilled for conviction, wherein in the instant case, the evidence led by the prosecution does not fulfill the prerequisites to invoke presumption under Section 304B IPC or Section 113B of the Indian Evidence Act. Even the ingredients of Section 498A IPC are not made out for the same reason as there is no evidence of cruelty and harassment to the deceased soon before her death. Protection under Section 19(2) of Prevention of Food Adulteration Act is available to the vendor only if food article is purchased by him within written warranty. In the case of Shri Mahavir Agencies and another versus State of West Bengal and another, the Supreme Court of India clarified that shield under Section 19(2)A of the Prevention of Food Adulteration Act in relation to the sale of adulterated food is available to a vendor if it is provided that the vendor purchased the article of food from any manufacturer, distributor or dealer within a written warranty in the prescribed form. In this case, the appellant was convicted by senior municipal magistrate for offences punishable under Section 16AI, read with Section 7 of the Food Adulteration Act 1954. The bench of Justice Abhay S. Oka and Justice Rajesh Bindal noted that there is a bar on the manufacturer or distributor or dealer to sell any article to any vendor unless he has given a warranty in writing about the nature and quality of such article to the vendor. The cash memorandum or invoice in respect of the sale or any article of food given by a manufacturer or distributor or a dealer in such article to the vendor thereof should be deemed to be a warranty given by such manufacturer. Hence, the court considered a valid defense raised by the appellants in terms of Section 19(2) of the Act as packed items sold had a written warranty in the prescribed form from the manufacturer and allowed the appeal. Writ of mandamus is prerogative writ. Court cannot exercise such power in absence of any legal right. In the case of South Indian Bank Limited and others versus Naveen Matthew Philip and another, The Supreme Court of India, while restricting the power of High Courts under the ambit of Article 226 of the Constitution of India, held that when a statute prescribes a particular mode, an attempt to circumvent shall not be encouraged by a writ court. The bench of Justice Sanjeev Khanna and Justice M.M. Sundaresh questioned the steps taken to recover the dues on the failure to comply with the one-time settlements, while the extraordinary jurisdiction of the High Court was sought to be invoked. The Supreme Court held that approaching the High Court for the consideration of any offer by the borrower is also frowned upon by this court. The court further held a writ of mandamus is a prerogative writ. In the absence of any legal right, the court cannot exercise the said power. More circumspection is required in a financial transaction, particularly when one of the parties would not come within the purview of Article 12 of the Constitution of India. The powers conferred under Article 226 of the Constitution are rather wide but are required to be exercised only in extraordinary circumstances in matters pertaining to proceedings and adjudicatory scheme, qua a statute. More so in commercial matters involving a lender and a borrower, when the legislature has provided for a specific mechanism for appropriate redressal. Whether the power granted under Article 226 extends to make amendments in registered lease deed. The Supreme Court of India, in the case of Gwalior Development Authority and another versus Bhanu Pratap Singh, clarified that it is nowhere open for the High Court to alter or amend a lease deed registered under Section 17 of the Registration Act in the exercise of its jurisdiction under Article 226 of the Constitution. The bench of Justice Ajay Rastogi and Justice Bella M. Trivedi in the judgment noted that the appellants had issued an advertisement inviting bids for the grant of leases of different plots under the Transport City scheme, and the offer of the respondent being the highest bid was accepted. The bidder was therefore directed to deposit an amount in addition to the earnest money in 4 installments. Despite the respondent failed to deposit the installment, no action was taken by the appellant. But, however, after more than 3.5 years, the respondent filed a writ petition in the High Court seeking a mandamus against the appellants for the execution of the lease deed. The Apex Court asserted that after the transaction is concluded and the instrument being registered under the law, it was not open to either party to question, at least in the writ jurisdiction of the High Court under Article 226 of the Constitution, and the mandamus issued by the High Court to execute the lease deed for the remainder of the area without the transaction is concluded and the instrument being registered under the law. Thank you, and keep watching Verdictum, the dictum of truth. Subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with the latest legal developments.